So good morning, everyone. Thank you for joining our session. Our session is NETLIP Housing Learning Series, Session 3, Common Tenancy Issues with the Role of Community Organizations in Providing Support. I'm the host. My name is Isabella Yan. I'm the Settlement Language Coordinator with Northeastern Local Migration Partnership based at Work Women Community Center. And this session is organized by NETLIP Newcomer Housing Task Group. And this is our third session of a learning series. And the session is tailored for the frontline workers, including like settlement worker, housing worker, mental health workers. Actually, it's for everybody. And today, the session is focusing on the common tenancy issues and the role of the community organizations in providing the support. The session will provide an overview of common legal issues low-income renters face related to their tenancy, and will provide guidance on how best to advise and support such tenants. The session will also explain the role of community legal clinics, tenant advocacy organizations, and housing support programs for tenants who are facing evictions. The session will also provide a general overview of what legal options are available for tenants seeking to enforce their rights. So for your information, the session is recorded and will be uploaded to NETLIP website and our YouTube channel. I like to start session by acknowledging the land on which we are situated is the traditional land of Huron-Wendat, the Seneca, Haudenosaunee, and most recently, the Mississaugas of the Credit River. We also acknowledge that Toronto is covered by Treaty 13. This territory is the subject of the Dish with One Spoon, One Belt Covenant, a treaty between the Anishinaabe, Mississaugas, and Haudenosaunee that bound them to share the territory and protect the land. Subsequent indigenous nations and peoples, settlers, and all newcomers have been invited into this treaty in the spirit of peace, friendship, and respect. Our NETLIP is committed to advancing the reconciliation work with indigenous peoples in the work we do, specifically in the settlement sector. Through continued learning, engagement, and collaboration, we strive to build more meaningful partnerships between indigenous and newcomers communities for generations to come. That's our agenda today. First, I'm going to introduce our presenter. Welcome back, Rebecca. Then she will do the session, and we have a Q&A session. We also have feedback from the closing. So that's our Rebecca. She did our first session, actually, understanding the housing terminologies. Welcome back, Rebecca. Rebecca is the housing lawyer who works at the Willowdale Community Legal Services. She assists individuals who are seeking legal advice about their rights and responsibilities as tenants, and she represents tenants who are facing legal proceedings at landlord and tenant board. Rebecca, the floor is yours.
Awesome. Thank you, Isabella. So I'm going to maybe we'll flip the screen over so I can share my screen. Okay, does that look good? Could I get like a thumbs up from someone?
It's perfect, actually.
Awesome. Great. So thanks so much for the intro, and hello again to everybody who was here the first time that I did a presentation a couple of months back about just kind of the language of housing law and the language of a housing crisis that we're always talking about being in. Today, I'm going to focus more on legal clinics, and I imagine many folks in the room are familiar with legal clinics or have had some contact with us in the past. But I just want to make sure that everybody here knows what we are and know how great of a resource we can be for clients that we might mutually be serving. So, to run through the agenda here to give us a sense of what we're going to be covering. First, I'm just going to start out by giving a kind of intro about what the role of legal clinics is when it comes to supporting tenants. Second point is going to be discussing how and when to make a referral to a legal clinic. I think there's probably a fair number of tenancy issues that your clients might come across that you might be able to handle and that it won't require a referral to a legal clinic. But then there's probably quite a few situations where it makes sense to just make that referral to make sure that your client has legal advice. The main part of the presentation, I'm going to be going over four different legal issues that I most commonly see the clients at our office facing. And these are issues that are initiated by landlords, so rent increases, and then three different types of eviction proceedings that tenants might be facing. We'll go through that in detail. Then I want to talk for a bit about tenant advocacy strategies. Um, there it can be quite limited what tenants are able to do in order to quickly enforce their rights. However, there are some strategies that could be helpful for you to just keep in your back pocket if you have a client who comes in who's having an issue, you know what kind of suggestions or referrals you might make. And then, of course, want to end it off with questions. I've tried to incorporate questions that folks had written in the initial sign up sheet into the presentation. So you'll see some questions throughout. You might see your question on the screen. And so I really do want to make this conversational. And so we can kind of pause after each section. And if folks have questions, I'm happy to kind of chat and answer questions as we go. So first of all, what is the role of legal clinics in supporting tenants? So our main role is to provide free legal services to people who kind of have to meet two criteria. One is that they live in our catchment area, and another is that they meet our financial eligibility criteria. So maybe you're familiar, legal clinics in Ontario are funded by Legal Aid Ontario. And there's a legal clinic for every single person in Ontario. There's just different catchments all across the province. There are many catchments throughout the city of Toronto. And so it's important to first figure out like where's your first stop? Like where is your legal clinic? For many folks who are probably in the room, it might be my office that is the legal clinic for your client. But that's the role of the intake staff when somebody first comes to our office is figuring out, okay, where do you live? Are you even in the right spot? The second piece about financial eligibility, this is because we have a mandate from Legal Aid Ontario to serve low-income neighbors in our catchment area. Um, we're pretty flexible with this. Like we are happy to provide information and resources and legal advice over the phone or in a meeting with tenants who might not quite meet our financial eligibility criteria, meaning they might make a bit more money than the cutoff says they're allowed to make and still receive services from us. But in terms of who we are signing retainer agreements with and actually representing at the landlord and tenant board, for example, people need to meet the financial eligibility. And so that's something that we would discuss with people when they come to our office. We wouldn't initially turn anybody away because they make too much money, though. We're always happy to provide legal advice to people who need it. And then kind of give them an idea about where their next best stop would be if they're looking for further legal support or representation. When it comes to tenants, so just as kind of even further background, legal clinics, we provide legal services in multiple different areas of the law, mainly immigration, social assistance or income maintenance, employment, and housing. But of course, for the purposes of today, we're talking about tenants and tenancies. And so the housing law teams at legal clinics, we typically have a mandate to focus on eviction prevention, which means that we are kind of triaging cases that come in. And if the case could potentially result in eviction for a tenant who's calling us, that's where we're gonna put our resources. We want to be keeping people housed, making sure people are staying in their homes, making sure that affordable rental units are staying affordable and people are not being evicted from those places. So in terms of the actual services that we provide, I've mentioned summary legal advice. Summary legal advice is just a way of saying like kind of uh general like non-retained legal advice about, somebody calls us up, they explain their situation to us. We can give them legal advice about what their options are, what we think maybe the strengths or weaknesses of a case might be, that kind of thing. That's the most common type of work that we do is it with housing law is providing that type of advice to people. And so if you ever have clients who, and we'll get to this in a moment, but if you have clients who are just kind of stuck on trying to figure out what their legal options are, rather than going down like a Google or a ChatGPT rabbit hole of like, what is a tenant's right to this in Ontario? Just refer them to a legal clinic. Like it's much easier to make sure you're getting good and clear and straightforward advice than going down the AI kind of internet hole where sometimes the advice isn't actually correct. The second most common type of service we provide would be actual representation. So signing a retainer with a tenant who is facing eviction. For those who don't know, in Ontario, when a landlord wants to evict a tenant, they need to file a case at the Landlord and Tenant Board, which is like a specialized court that deals only with tenancy matters in Ontario. And so if people have a hearing coming up where they're possibly facing eviction, that would be a really common role for us to come in and represent them and support them at that hearing. We also assist with tenants communicating or negotiating with their landlord, like if they're looking to set up some kind of repayment agreement with their landlord for some money that's owed, or they're looking to move out, but they just need some help coming up with an agreement about when and how they're going to move out. We can assist people with that type of thing. Also help people with reviewing documents or reviewing agreements before they sign them so that they know what they're signing is understood and they know what their legal obligations are before signing that document. And we also make referrals to community agencies. So that'll come up throughout the presentation, kind of at different points where it might make sense for a different community agency to come into the fold. So th those are the services we provide. Um, and so I guess for the folks in the room who are doing frontline service provision to tenants in Toronto, it's good to know like when should you be making that connection? When is it important for people to be speaking to a legal caseworker about a housing matter? First and foremost is if they've got some documents. So there's three different types of documents I listed here. If there's any other type of document that your client comes in with that you think it might have to do with eviction, I would say tell them to get legal advice. It's always better to get legal advice than to possibly wait, and perhaps the situation might become more dire or more urgent. But the first type of document I note here is called a notice of termination. So I know some people in the questions had identified, I think N4 was brought up, and what we will talk about notices of termination in a bit more detail in a couple slides from now. But a notice of termination is the first formal legal document that a landlord has to serve on a tenant before they want to evict them. And it always starts with the letter N, N for notice. N4 is about maybe the tenant owes rent money. N7 is about the conduct of the tenant potentially impacting others' safety on the property. N12 is about a landlord wanting to evict a tenant because the landlord wants to move into the rental unit. There are lots and lots of different types of N forms, but some of them come with really important timelines that require the tenant to do something within a certain amount of time. And so if you have a client who comes in with a notice of termination, an N form of any type, I would say connect them with a legal clinic as soon as you can, and let the legal clinic know the type of N form that the tenant has received and the dates on it so that we can know where are we at in the proceeding. Like was it served a long time ago? Was it just served and there's still time to maybe change something that could fix the legal problem? We need to know the timelines of that notice of termination. The second type of document is any documents from the Landlord and Tenant Board, which is the logo I have on the screen here. If you see a document with this logo on it, tell your client to get legal advice, connect them to a legal clinic. Like I said, the Landlord and Tenant Board is the court, the specialized tribunal that deals with landlord and tenant matters in Ontario. If a tenant has a proceeding at the Landlord and Tenant Board, it is incredibly important for them to show up on the dates that they are told they need to show up or submit documents and requests to reschedule well ahead of time. It's important that tenants file documents related to the case on time. It's important that if the tenant requires an interpreter, they're submitting a request for an interpreter well ahead of their hearing. So there's lots of really important obligations that are put on tenants when they have cases that are being heard at the LTB, whether they are the ones who filed the case themselves, or whether, and this is the more common type of situation, whether the landlord has filed a case against them and is trying to evict them. The stakes of what could happen at a landlord and tenant board proceeding are very, very high. People can lose their home and they can lose their home on a very quick timeline. And so making sure that the tenant is well prepared, is meeting their filing deadlines, is showing up when they need to with either a representative or a support person or an interpreter with them is really, really, really important. So if your client comes in, they've got anything from the LTB, you're not even really sure if they have a hearing coming up, doesn't matter. I would say tell them to get legal advice. And then the third type of document that I wrote on the screen here is called a sheriff's notice to vacate. And so this type of document, it's not an N form. You won't see landlord and tenant board written on it. It's actually from the Superior Court of Ontario. And it's the type of notice that somebody receives a few days prior to them being evicted. And it will provide the date and the time that the sheriff is going to come to enforce the eviction. And just, I guess, maybe for background for people, so you can kind of understand the timeline of things if you have a client coming in with a sheriff's notice to vacate. The first step, like I said, is that a landlord needs to serve a notice of termination when they want to evict someone. They will then file at the landlord and tenant board. A hearing will take place. An order will be issued from the board about whether they're being evicted. And if they are being evicted, then following that, the sheriff gets involved. And the sheriff is the only kind of office in Ontario, in Toronto, that can actually enforce an eviction against a tenant. And so when a tenant has received a notice from the sheriff saying they're coming, we know that the timeline is really, really tight, and there's going to be urgency about that person needing to put things in place to move out of their home. And so it's really important they get legal advice if they have a sheriff's notice to vacate and they either don't know, they didn't know that it was coming, they didn't know there was a whole proceeding that had happened leading up to that point. Um, I would say that's the document that requires the most urgency to act with. Lots of times, though, landlords aren't going to serve tenants with the proper legal notice. They might start for a while with verbal threats to evict or informal written threats to evict. And that can be really unsettling, of course, for any tenant. And so if you have a client who's coming in and they're showing you text messages from their landlord, or they've got some email from their landlord saying that they need to be out by a certain date, but they don't really know why, I would say tell them to get legal advice. Make a referral to a legal clinic. And we can talk through with them what might be coming next, what the tenant's rights are in that situation, and what the landlord should or shouldn't be doing in that situation. So even if they don't have any formal document about eviction, but they're feeling uneasy about the possibility of eviction, make a referral to a legal clinic. And then the final 2 points on the screen are about the tenant wanting information about their own rights. And it's not that anything is being served on them or that they're facing eviction, but it's about they want to know what their rights are, what maybe their obligations are as a tenant. We're happy to do summary legal advice. We're happy to chat with tenants who have questions about their own rights as tenants and what they should be doing throughout their tenancy. And I believe I mentioned this on the other slide, but if you have a client who's maybe moving into a new rental unit, they got a copy of the lease agreement from the landlord and they're trying to figure out, is this legal? Are the terms in this lease agreement legal? I feel uneasy about, this clause. Am I able to take it out? Or if maybe you have a client who's moving out of a rental unit and they're signing maybe an N11 or a form that is about ending a tenancy, and they want to just make sure that they're doing everything right and that they're not going to be on the hook for anything after down the line, refer them to a legal clinic. Like we're more than happy to talk to people who are in kind of transition phases, looking at documents, trying to sign documents and not really sure what to do. And we can get on the phone with them and just walk it through with them and answer any questions so that they know what they're legally binding themselves to by signing an agreement. So next question is how to make a referral to a legal clinic. First step, like I said, is you need to make sure you're in the right catchment area. And so the best and the easiest place to do this is the Legal Aid Ontario website. You can just Google Legal Aid Ontario postal code lookup or something like that, and it'll bring you to this page where you just pop in your client's postal code and it will tell you which legal clinic is their legal clinic. Sometimes a postal code area covers two different legal clinics catchment areas, and so you'll need to put in the exact address. So just make sure you have your client's address. And then you know where they're going to be able to go to get free legal support. You can then either call the clinic with your client, if the client would prefer that, or just give them the contact information. It's super rare that we would take a referral only from a caseworker, unless the caseworker has like really detailed information from the tenant about what's going on, any relevant documents, of course, consent from the tenant to share all of that information with us. It's we find it's typically much easier and much more straightforward if we can just speak directly to the tenant. And so if you are not able to either get through to somebody on intake at the legal clinic you're contacting, if you're there with your client, or the client doesn't want you on the call, just make sure you provide them with the contact information. Please advise your client that it might not be, a response within a day. It might be a couple of days. Legal clinics we're very, very busy. We have a lot of new files coming in every day, and of course, we want to make sure that we're responding to each of them with the right amount of care that it deserves. And so, typically, I think legal clinics will ask for a couple of days before you're going to get a call back from a caseworker to discuss the matter. If it's urgent, like I was saying, if there's maybe a sheriff's notice to vacate or there's some kind of threat of something imminent happening, make a note of that. Really encourage your client to make a note of that. And we will, of course, take that into account when we try to get back to people as quickly as possible. And then, I mean, I'm sure this is just common knowledge for most folks who are working directly with clients, but just follow up with the client, make sure they did contact us, and make sure that they were able to get connected to a caseworker. Now, I put a question on this slide that I saw in the sign up questions, and it was, can a support worker represent a client at a landlord and tenant board hearing if the caseworker is well aware of the situation and can advocate for the client? So, in short, yes, the landlord and tenant board has rules that govern its proceedings, and people who are non-lawyers or non-paralegals are absolutely able to represent clients, represent tenants who are before the landlord and tenant board. You could act as a representative, you could act as a support person. So there's kind of different roles you can play depending on what you want and what your client wants your role to be at the hearing. I would recommend though that if you're planning to do that, and if you have any questions about what's going to happen in the hearing, or maybe if you already think that you kind of have an agreement with the landlord that you're just going to help your client enter into, if you have any questions of what might be included in that agreement, like give us a call, just check in. It might be helpful to just run things by somebody who can give just their legal opinion on what you're going to be doing. But then absolutely, you're able to represent a tenant at the landlord and tenant board. You don't need to be a legal caseworker to do that. But it is best to always just get legal advice ahead of time so that everybody knows what the legal consequences of what the tenant might be doing at the hearing or in a settlement agreement might be. I also mentioned support workers. So a support worker is somebody who can show up at the landlord and tenant board with the tenant, with the party who's named in the proceeding. You're not speaking for them, like you're not making submissions for the tenant or on their behalf, but you're able to maybe help them remember some of the evidence that they want to give or communicate with the landlord, or you could act as an interpreter. So there's the landlord and tenant board kind of allows for multiple roles to be played by people who are showing up with tenants. Now, I just want to check the chat. Any questions? Maybe I want to pause here before we get into the legal issues that tenants commonly face. And I see a question about will you provide interpreters? So yes, legal clinics have access to on-demand interpreters. We can book in-person interpreters. We are able to access them on the phone immediately. So if intake staff is speaking with somebody and they require an interpreter, absolutely, they can get somebody on the line. And then the caseworker who's assigned to that file will always make sure that there's an interpreter available when they're speaking with that tenant. Sorry, I'm just reading through the questions here. So there's another question that says, can a client have a support worker and a legal clinic lawyer? Yes, you can totally have both. And that's great. And we appreciate it so much when tenants and clients have folks who are showing up with them, who want to support them, who are there just as emotional support with them. The only thing I would say is if a tenant is they have a hearing at the landlord and tenant board where they are going to need to give evidence or give testimony about what has happened, and they want to also have somebody in their life come and give evidence or testimony about what's happened to them, that person is going to need to be out of the room when the tenant is giving their testimony. There are rules around witnesses. So if the support person can't be both a person and a witness, it would need to be one or the other. But absolutely, support people are able to assist, even if the tenant has a lawyer or a legal representative. Okay. So first legal issue, like I mentioned, super common question that a lot of folks come to our office asking about is about rent increases. So there are basic rules around rent increases that maybe some folks in the room know. Maybe you're a renter also and you know what the rules are, but just very simply, landlords are allowed to increase rent once every 12 months. They need to give a tenant 90 days notice before increasing the rent. And for rental units which are covered by rent control, which is the majority of rental units, although there still are many that are not, but if a rental unit is covered by rent control, then it means that the landlord can only increase the rent by the percentage that the government has set out for that year. So every year, the province of Ontario says, okay, landlords, you can charge however much percent. So for 2025, it was 2.5% they were allowed to increase rent by. For 2026, we know it's going to be 2.1% they're going to be allowed to increase rent by. And in most circumstances, they are not allowed to increase rent by more than that. However, we are seeing landlords increase rent by more than that amount through a couple of different means, and one and the most common one is through above guideline increases, or AGIs or AGIs, if you've heard of this acronym. Above guideline increases are special rules that are set out in the law, giving landlords permission to increase rent by more than the 2.5 or 2.1%, as long as they can show to the landlord and tenant board that special circumstances apply. And there's different types of circumstances, but it requires the landlord to essentially file a case at the landlord and tenant board and ask for permission, like get permission to charge more than the amount the government said they previously could charge. And if they get that permission, then tenants are going to be slapped with an order from the LTB that says, actually, your rent is going up by 2% more than what we thought it was. Or in the case of above guideline increases, often they take a couple of years to get processed. And so often tenants will receive letters a couple of years down the line saying, hey, your landlord was just approved for an above guideline increase in October 2023. So you now owe us 2 years worth of retroactive rent. So above guideline increases are really unfair for tenants, and there's advocacy happening in the province to restrict and to get rid of above guideline increases. And so this is the first kind of community referral that I would like folks to take a note of is a really great organization called the Canadian Centre for Housing Rights. They do a bunch of different things, but they have lawyers who work with them in the organization who specifically support tenants with above guideline increases. And so if you have a tenant who's come in with the type of letter that I just described, where, the letter says the landlord and tenant board has approved your landlord for an increase going back to 2023 or 2024. You now owe us $1,500. And your client is saying, oh, shoot, I don't know what to do. I would say make a referral to a legal clinic. If your tenant is coming in and they've got documents indicating that their landlord has applied for an above guideline increase, but it hasn't yet been decided by the board, like the landlord and tenant board hasn't yet said, okay, we're giving you this permission, there's still going to be a hearing that will take place where the landlord has to prove that they need to increase rent by more than the guideline amount. I would recommend that you get them in touch with the Canadian Centre for Housing Rights. And I believe this PowerPoint will be distributed, and if you click that, there's a link that will bring you to the CCHR website, where you can see more about their contact information and what types of services they provide. But they assist tenants who are preparing for hearings at the Landlord and Tenant Board that deal exactly with this issue. The image that I have on the screen it's an N1, it's a notice of rent increase. And this is the document that tenants receive when their landlord is planning to increase their rent. It has to have all of the correct information on it. It has to have the correct date that the rent increase will take effect. And like I said, it has to be at least 90 days in the future. And then it will have a breakdown of what the new rent will be and what the percentage increase will be. And then I wasn't able to fit it on the screen, but further down on the sheet, it talks about whether the increase is an above guideline increase or not. And so if the tenant is wondering, like, why is my landlord increasing my rent by 4%? I thought the guideline was only 2.1%. It could be because the landlord has applied to the board for an above guideline increase. Okay, one really good question in the chat about how do we know if the rental agreement is controlled or not controlled? So, buildings that were built or used for residential purposes after November 15th, 2018 are not covered by rent control. This was a change put in place by the Ford government, um, meant to open up the market, and we've seen it have a disastrous effect on rents and how expensive rent is. So like most, I would say a lot of people who live in Willowdale is the clinic that I work at. In our catchment area, if they live in a rental unit, it's probably a high-rise apartment building that was built maybe like 30 or 40 years ago. Those are totally covered by rent control. It's more so newer builds, new condo buildings that are being rented out, new houses that have been built. Um, so it's really about the newness of the building. So if the tenant knows approximately how old the building is, that'll give you a general sense of whether or not it's rent controlled. You can also just if I'm ever feeling unsure, I can Google the property, and a lot of property websites will have information about the year it was built, especially if it's a newer build. But that's the main thing. November 15th, 2018. If it's was built after that date, then you're not covered by rent control. So I won't spend too long in the chat just to make sure we keep moving. But one good question about um, somebody asked, in all cases, do tenants have to pay the AGIs from the past, or are there ways to reduce this? The unfortunate thing is there's not ways to reduce it once the landlord and tenant board has issued the order, or it's incredibly difficult to reduce it once the order has already been issued. And by the order, I mean like once the board has given the landlord permission to charge it, it's hard to change that amount. However, there are some agencies that maybe folks in the room are familiar with, like Rent Bank or like Epic, which I'm going to talk about in a moment, that help people pay off rent arrears and avoid eviction. And those types of organizations can help out when a tenant owes rent money as a result of an AGI. So although the actual amount that the landlord is getting is not reduced, perhaps the amount that the tenant themselves has to pay is reduced because a community agency might be able to come in and cover part of the cost of it. And the question was also asked about people renting in basements, what guideline I guess like applies to people renting in basements. It doesn't matter if you live in a basement. If the basement was built and being lived in prior to November 15th, 2018, then you are covered by rent control. If it was after, then you're not covered by rent control. So whether you're in the basement or on the 25th floor, it doesn't matter. It's really just about the date that that unit was lived in and built. Okay, the next legal issue, and this is probably the most common type of legal issue that we assist tenants with at our office, is eviction for rent arrears. And so, as you'll remember at the start, I said that the very first step that a landlord needs to take when they want to evict a tenant is serving a notice of termination, an N form. And so, when it comes to rent arrears, it's going to be an N4, a notice to end your tenancy for non-payment of rent. On any N form, any notice of termination, there's going to be a box that looks like the one on the screen in the red box that provides a date, and it says this is called the termination date. And when a tenant receives one of these forms, there's obvious pressure that, the form induces pressure to move out by that date. It makes it seem like you have to either pay however much money the landlord is claiming you owe or get out of this property by the date. The most important thing for you to remember if you're advising tenants who come in with this type of a form is that the tenant does not need to move out by that date, and there's nothing immediate that's going to happen that's going to like end their tenancy on the next day if they don't move out by this date. This date is meant to just put pressure on a tenant to pay money to their landlord on an N4. The provincial government has introduced Bill 60 recently, which is seeking to make a bunch of amendments to tenancy law throughout the province. And part of that bill would be amending the amount of time that somebody has to pay off the money that a landlord is claiming they owe on an N4. And this is really difficult because if the tenant doesn't pay by that date or doesn't move out by that date, although they can't be immediately evicted, the landlord can then file a case at the Landlord and Tenant Board for eviction based on the rent arrears. So they need to give a tenant at least 14 days to pay off the rent arrears. If they don't, then they can file at the board and then the legal process will begin for an eviction hearing getting scheduled. But keep in mind, if a client comes in, you see an N form, you know it's a notice of termination, a landlord is trying to evict the tenant. One is tell the tenant you don't need to move out by this date. Don't frantically move your whole family out of the apartment by this date. To get legal advice and start putting a plan in place about what they're going to do about the allegations in the N4. We know the N4 is about money, and we know that most tenants who receive N4s owe money not because they want to, not because they just don't want to pay rent or want to stick it to their landlord, but because living in Toronto is incredibly expensive, the cost of living is incredibly high, and the pressures on tenants to make payment on time and in full to their landlord are really, really high. So oftentimes I think in media we might see stories that's really framing tenants as, withholding money, being able to live in a rental unit rent free for months and months and months. And I think that those cherry-picked stories they tell an inaccurate story about the reality of tenants. And I'm sure many folks here in the room, you realize that if your clients who are tenants have fallen behind on rent, it is not a personal kind of screw you to the landlord. It's a result of poverty and it's a result of the inability for people to make ends meet. And so knowing that, there are some great places that can assist tenants who owe money. So these are kind of the next community agency referrals that folks can keep in mind. The first is Rent Bank. This is a program run by the City of Toronto that can provide financial support to people who are facing eviction because of rent arrears. So if a tenant has received an N4, we know that they're potentially going to face eviction down the line because this was step one in the whole eviction proceeding that the landlord needs to take before they can evict the tenant. And so there's information online about Rent Bank. There's a phone number you can call. You can get connected to them through 311. You can make that referral yourself. That is not something that a legal clinic needs to make a referral for. Rent Bank has their own criteria. Like they don't just kind of give money to anybody, but there's limits about how often tenants can access funds through the Rent Bank, what the tenant's income is, how many people are living in the house. That determines kind of what the income cutoff is. And another really important criteria that applies to all three of these community organizations that I'm going to talk about is that they are only able to help tenants if the tenancy is sustainable. And what I mean by that is the tenant needs to show that they at least have enough money coming in through income or government benefits or family support or roommate income to be able to actually afford rent going forward. Like Rent Bank wants to know that, okay, if we help you pay off the $2,000 you owe this month, you're not going to be in the exact same position next month. Like you're actually going to be able to afford it. And so these programs, they work really well for people who have had kind of a momentary blip in their ability to pay rent. Like maybe they were laid off from work for a couple months, maybe they were sick, they weren't able to pick up as many shifts as they previously were able to. Maybe they had a roommate who moved out and they were without roommate income for a couple months, but now they have a new roommate who's moved in, and that only for a period of time they were unable to afford the tenancy. That's where these programs are able to come in and say, we got you, we'll help you cover that off because we know you can afford it going forward. But these programs are not helpful if the tenant just simply can't afford the rental unit. If their income is $1,500 a month and their rent is $1,400 a month, like that's just not going to cut it. That's not reasonable. Or if their rent is, of course, higher than their income, then these programs are not going to help. And so before making a referral to Rent Bank or the Housing Stabilization Fund, which I'll talk about in a minute, it might be worth it for you to talk to your client about like, is this place actually affordable for you? Are you actually going to be able to afford rent going forward? Because that's what these organizations will be looking at. Epic is very similar to Rent Bank in that they can help people with finances, with paying off debts that might be owed to avoid eviction. But they also provide really good kind of wraparound support for a tenant with maybe budgeting, with connections to other resources. They kind of come in, they'll meet with the client in person, and they'll do more holistic support for a tenant who might be facing eviction. But because of that, because they're more like an enhanced program, they require a specific referral from a referral partner. So maybe some of the organizations, some folks here work at are referral partners and you're able to make that referral. But if not, legal clinics are referral partners for Epic. So if you're thinking that they would need some help getting into a program like Epic and that could really help them save their tenancy, make a referral to us and then we can be the one to make that connection. The final resource on the screen I wanted to just mention is the Housing Stabilization Fund, or the HSF. This is exact same idea as Rent Bank and Epic, like kind of a pot of money that tenants have access to try and pay off arrears to avoid eviction, but it's specifically for people who receive OW and ODSP. In order to apply to the HSF, you typically need to go through the tenant's worker. And so for those of us who do work with OW or ODSP workers, we know sometimes it can be incredibly difficult to get a hold of workers and to make sure that they've submitted the application to the HSF. And so that's where it would be really important for you as perhaps the support person in the client's life to kind of keep up with that advocacy with the OW or ODSP worker to make sure that the HSF application has been submitted. And one thing to note about the HSF is that if they are able to provide financial support to tenants who need it, one thing that they typically always require is that going forward, the tenant's portion of rent that's being paid by OW or ODSP has to be paid directly to the landlord. So if a client is receiving their full OW or ODSP benefit through them, and then they are the one responsible for paying it to the landlord, that process would stop if they receive HSF. They need to kind of give up their claim to the portion of rent that's their shelter allowance, and that will be now directly dealt with between the landlord and ODSP or OW. And for some people, that's not worth it for them. Like they don't want to give up that level of autonomy of their finances and control. And that's fair enough. And so it's important also to explain kind of the risks of applying to the HSF and what that might mean. If they do get financial support, it might mean that they kind of lose some of their other autonomy with their finances. Somebody said, can you talk more about Epic? I could. And okay, awesome. So Isabella just said that there's a session for those who can't see the chat. There's a session being organized on Epic in January, February, which is awesome, and I look forward to attending that one. So stay tuned for that. Okay. So another question here that was in the questions for people who had registered for this I guess conversation was how do we assist clients with keeping their housing when landlords attempt to price out tenants? This is forever the difficult question that those of us working in housing are kind of grappling with because there are rules around how and when a landlord can evict tenants, but we know that landlords can also be kind of sneaky. And that's because of something called vacancy decontrol that I just want to briefly talk about. I might have talked about this in my first presentation a couple months ago, but it's this concept where landlords are allowed to, well, we know that when a tenancy exists, as I said earlier, a landlord is only allowed to increase rent by the percentage set by the government every year. But as soon as that tenancy ends and the tenant moves out, the landlord is allowed to increase rent by however much they want in between tenants. And so we know that there's an incentive for landlords to kick out long-term tenants because they know that as soon as they get them up, they can double the rent. They could hike it up by $500 a month more. And they would never be allowed to do that during the tenancy if the tenant remained in the rental unit. So we know there's this incentive by landlords to get long-term tenants out. Sometimes that kind of plays out in a bit of a sneaky way where tenants don't realize what's happening. So, when a tenant first moves into a rental unit, if they sign a lease agreement or they verbally agree to a lease agreement with their landlord that they're going to be living there for a certain number of months, and then those months are up, say it was 12 months, they'd been there for a year, the tenancy doesn't end after those 12 months. It just continues and it continues on a monthly basis, which means it's called security of tenure, that tenants are just allowed to keep living there. That's how the law works in Ontario. But sometimes landlords might ask the tenant, well, let's renew the lease. Let's sign a new document. Let's say you're going to be here for a set number of months more. And in doing that, they can ask that the tenant increase the rent by more than the percentage amount that the government says they're allowed to increase it by. And sometimes I speak to tenants who unknowingly, sign a new lease agreement or agree to a rent increase that's above the guideline amount because they didn't realize that they had security of tenure and that they actually were just allowed to keep living there and have their rent increase governed by the guideline amounts that the government sets. And so I want to draw this point out because this is an important way that we can assist tenants with not getting priced out and not agreeing to rent increases that are illegal, is make sure they get legal advice before they sign anything new or before they agree to anything new with their landlord. And sometimes, landlords can be very compelling and understandably like maybe they're having a tough time with their bills and they're kind of putting that stress onto a tenant who maybe rents a unit in their basement or something like that, and tenants can of course get very swayed by that and they want to maintain peace in their tenancy and they don't want to be abrasive or difficult with their landlord, so they might agree to things that they didn't realize they didn't actually have to agree to. So one way to assist with this, with keeping people housed in affordable units, is making sure that they are getting the correct advice before they agree to a rent increase or sign anything new with their landlord or agree to move out. It's important that tenants understand they have security of tenure. They do not need to move out at the end of a fixed term lease, and they can only be evicted if the landlord has a proper legal basis to do so and goes through the LTB process. I see a question saying this includes controlled rents, and I don't know what this question is referring to. I'm wondering if Miriam, you would be able to just clarify before I move on. Oh, yes. So the idea that a landlord can increase rent by however much they want, that absolutely applies to units that are covered by rent control. It's like all the rent control rules go out the window as soon as a tenancy ends, and the landlord can start fresh with whatever they want. And so we sometimes see tenants, well, frequently actually, I speak to tenants who they've received a notice of eviction. They can tell their landlord is trying to get them out, and the reason for the eviction doesn't really make sense to them. And then they begin to tell me, well, I've lived here for 25 years. My rent is actually like way below market rent. I really don't want to lose this housing. And maybe their landlord, I was actually speaking with somebody yesterday, and their landlord had explicitly told them, I could be charging $600 more a month for your unit. And the landlord is naming the issue, which is that they know they're losing potential profit on this rental unit, and then they're putting that pressure on tenants. And so that's where it's important for tenants to really know their right to stay living there and stay living there until the proper legal process has gone on to evict them. Okay. The third of four legal issues I want to talk about is about eviction for behavioral type issues. So it's not about money, it's about the conduct of the tenant. There's multiple different types of notices that kind of relate to behavior. And the one on the screen here is an N5. An N5 is probably the most common type of notice that you would see about behavioral type allegations. And the cool thing about an N5 is that it is voidable, which means that the tenant can stop this notice from becoming an application at the landlord and tenant board if they do certain things. And typically that just means to stop the thing that the landlord is claiming they're doing. So if the landlord is making allegations about noise during the night, if the landlord is making allegations about maybe like a dog being off leash on the property, if the tenant corrects that behavior within 7 days, then nothing will happen, and the landlord cannot file at the landlord and tenant board unless there are future breaches. And I don't want to get too into the details of the timelines, but there's a 6 month window after the N5 is served where the landlord could serve a second N5 if the same issue is going on again. But it's important for the tenant to understand what the allegations are. And if they dispute what the allegations are, then they can just stop doing them. If the landlord seems to think that the behavior is continuing for some reason, then what will happen is the landlord will file a case at the landlord and tenant board, and the tenant will have the chance at a hearing to present their side of the story. Typically, when a tenant receives notices about their behavior, they're upset, and it kind of it's I feel like more with an N4, it's about money that's owing, and oftentimes people will say, yeah, like I mean, I didn't mean to not pay rent, but I wasn't able to, and I admit I owe the money. With an N5 or with an N6 is about illegal acts that the landlord is alleging has happened. An N7 would be about the tenant's behavior potentially impacting the safety of other people on the property. Like these can be really, really big and heavy allegations for people that would obviously make them really upset, and especially if the tenant disagrees with the allegation. So I would say it's always best for, I mean, every slide here, I'm basically saying tell your client to get legal advice, but especially with behavioral notices, it's important for the tenant to know what the risks are if they do or they don't void. It's important for the tenant to, I guess, get advice about the specific allegations in the N5. With these types of notices, there's a high onus on the landlord to provide detail about what the allegation is. It's not just like you're being rude to staff. That would not be sufficient. It would have to be on November 7th at 10:30 a.m. you called the superintendent a blank, and it needs that level of detail. And so that's also a helpful place to get legal advice is for somebody to review the notice and give our opinion about whether or not this notice would be sufficient at the landlord and tenant board to ground an eviction. I saw this question and it felt like it really relates to the issue of behavior and evictions based on behavior. And the question was asking for suggestions on how to handle clients that damage their units due to mental health issues that they refuse to acknowledge. And of course, step one is I would say tell them to get legal advice, work with them to make a referral to a legal clinic. By getting legal advice, you're not admitting that you've done the things that are alleged in the notice. Like that's important for people to recognize is that when they come to a clinic and they're speaking with a caseworker, we're not starting from the perspective of, well, the landlord said you did this thing, so you must have done it. We're going to be asking like, what's your side of the story? What's going on here? And it's always better to get legal advice than to try and brush it under the rug and say, well, I didn't do it, and so this isn't going to turn into a legal problem. It will turn into a legal problem if you don't address it. And it's so much harder for caseworkers to assist people when they come to our office and the hearing is 2 days from now versus they got the N5 and there isn't even an application that's filed yet. And we know there's months and months still before anything legal might happen. It's so much easier to put things in place, put supports in place ahead of time, rather than if somebody's just coming to us on the eve of their hearing. There's not much we can do at that point. So tell them to get legal advice. Remind them that getting legal advice is not admitting that you've done anything wrong, but it's about wanting to understand what your options are. And something to keep in mind that maybe folks in the room are familiar with is the Ontario Human Rights Code. It imposes an obligation on landlords to accommodate tenants. And accommodation could be simple with things like the property or the rental unit making renovations to the property to make it maybe physically accessible or accessible in other ways for a tenant. But they also have a requirement of accommodation when they're working with a tenant who's potentially facing eviction to explore what types of supports that person might need to put in place to avoid the behaviors that are leading to eviction. So for example, tenants who hoard, landlords have an obligation to inquire with the tenant about what types of supports they need to make sure that their rental unit is not posing a health and safety hazard for them or other tenants, a fire hazard for them or other tenants. And there's an obligation to not only put those supports in place, but to inquire with the tenant about what they might need to stop the behavior that's leading to really challenging outcomes and potentially eviction. But I think that the key part of this question that I can't ignore is that if the tenant is refusing to acknowledge what's going on or acknowledge their impairments or the disability that might be at play, it makes it really hard. And I don't think that there really is an easy answer. This is a big question that I frequently speak with other caseworkers at clinics about is just like how to navigate that. And I think the unfortunate answer is that our social services systems, our health systems, our housing systems are not set up to adequately support people who have really complex needs. We can do our absolute best to fit people into the mold that legally, puts them in the best position to save their tenancy. But if I can't get instructions from a person, from a tenant who's facing eviction to ask for certain remedies or to frame this as a disability, then I'm not going to be advancing those arguments on their behalf. I have to get instructions from the client about what they truly want. And so part of our job as legal representatives is also assessing that capacity and assessing, what type of instructions can we get from this person and how best can we leverage that to support them to maintain their tenancy. Because at the end of the day, like I said, our mandate is eviction prevention and we want to try and keep people housed. And so we will be as creative as we can to try and work with the tenant, work with whatever other supports are in place, and work with the landlord to try and keep them housed. But I'm not blind to the fact that sometimes you can't get that. And it can be really, really difficult when you're in a legal context and people are unwilling to admit to those things. Okay, the final type of legal issue that I want to go over is just about no fault eviction. So this is like the tenant is not at fault. The tenant hasn't done anything wrong, but the landlord is still allowed to evict them. There's a handful of legal bases for eviction that a landlord can use that are no-fault evictions. One is N12s, which is what I mentioned earlier. Maybe you'll see your clients have a lot of, I see a lot of those at our clinic. This is when the landlord is saying, I want to use the rental unit. I want to move back in. Or somebody in my immediate family unit wants to move in. And so we can see on the screen the N12 on the second half of the image. My reason for ending the tenancy is that the following person intends to move in and occupy the unit for at least a year, and then they check off who it is. These types of cases are really, really hard because in order for a tenant to be successful in stopping an eviction, they need to prove that the landlord is acting in bad faith and that the person who's supposedly going to move in is not actually going to move in. And it's so hard to disprove somebody's plan than to just show good faith. Like the landlord can just show up and they can say, yeah, I'm tired of renting. I want to stop being a landlord. I'm going to move back into my house, and the board will typically believe them. So these types of cases are really, really tough. I would say tell them to get legal advice. Tenants have certain rights to a notice period, like how much time they are given before moving out or before they are allowed to be evicted. Um, Bill 60 might change this, but also there's rules around compensation. So right now, if a tenant receives an N12, their landlord is required to pay them 1 month of compensation as kind of recognition that you've done nothing wrong, but I still need you to move out. We'll see if Bill 60 changes that. Kind of similar are the next two examples I have on the screen called rent evictions and demovictions. And those are like colloquial terms we use to describe evictions that are based on a landlord wanting to renovate the property or demolish the property. The form that the tenant would receive is not an N12, it's an N13. And similar to N12s, there are requirements of notice and compensation that's required to be paid to a tenant. And there are different legal tests that a landlord must meet if they want to evict somebody because they plan to demolish or renovate the unit. But we won't get into that now. One question is, if the landlord gets back their unit after the N12 process, but then after 2 months rents it out to another tenant, what happens? Okay, great question. Tenants have the right to then file a case called a T5 at the Landlord and Tenant Board if they realize they've been illegally evicted. So yeah, like maybe you get kicked out, your landlord is saying, oh, my parents are moving in, they need to have the condo, whatever. And then you're scrolling through Facebook Marketplace and you see your old unit up for rent 2 months later, or even 6 months later, or 10 months later. That's a really good reason for that tenant to file an application at the Landlord and Tenant Board and say, look, I was illegally evicted. The landlord did not do the thing they said they were going to do. There are pretty extensive financial remedies that a tenant can get at that point, like maybe the difference in rent that they had to pay at a new place they had to move into, moving or storage expenses, general compensation for the fact that they were illegally evicted, any out-of-pocket expenses. So there's quite a bit of money that a tenant can ask for at that point. Typically, it's nearly impossible to get back into that rental unit, especially if the tenant has like signed a new 12-month lease somewhere else. They're kind of locked into that. And so, of course, money can never really fix somebody being illegally evicted from a home, especially a home that was a home for a really long time. But they do have the right to file a case against their landlord, show the board proof of the rental posting, and say, look, like, I deserve compensation. Okay, so the final couple slides here are just about tenant rights. So we've gone through kind of four main issues that I see landlords bring up a bunch: rent increases and then evictions because of rent arrears, behavior, and no fault reasons. But tenants also have rights, and tenants also can take legal action against against their landlord. And so you might have clients coming in and they're dealing with these things. It's not about eviction, it's not about money, but it's just about the other parts of their tenancy, and they want to know what their rights are. So just in a basic sense, we can cover some basics here. So under the Residential Tenancies Act, which is the piece of legislation that governs tenancies in Ontario, the landlord has a duty to maintain a rental unit in a good state of repair and to address pest concerns. So pests could be anything from like bed bugs to cockroaches to mice. Um, the good state of repair is kind of a vague term. It's hard to really hold a landlord to a specific standard. But there's ways in which tenants can try to do that, which I'll get into. Another thing just to keep in mind, really topical right now, is about making sure rental units are heated properly. So this means that in Toronto, it has to be heated at least to 21 degrees between October 1st and May 15th. Kind of in a similar vein, a landlord's not allowed to interfere with a tenant's vital services, so supply of heat, electricity, or water. They're not ever allowed to do that. It doesn't matter what time of year. If tenants are finding that their landlord is not heating their unit properly, or has cut off a vital service, or isn't dealing with a pest infestation, for example, the kind of standard process that a tenant needs to go through is one, put the concern in writing. Make sure you have a text or an email, or some high-rise apartment buildings will have those maintenance request forms that you can fill out, and then you get the pink sheet that was on the back and you can hold on to that copy. The number one thing to remember is that a tenant needs to be keeping a paper trail of what they're doing, what they're requesting of their landlord. So first thing is, tenant needs to ask the landlord directly to fix it. And then depending on the urgency of the issue, they can then escalate the matter. So for something like heat or a vital service, if that's been cut off and a tenant is not receiving an almost immediate response from their landlord, then I would recommend the tenant call 311, which is the City of Toronto, and ask for a city inspector to come out to the property. So there's a division of the City of Toronto called MLS, Municipal Licensing Standards, and the city inspectors are able to come out to property, look at issues, talk to the landlord, and in some cases order the landlord to make certain repairs or to reinstate certain services. 311 is going to be the quickest response to get somebody out to the property. Um, if a tenant has asked the landlord several times to fix an issue, if 311 has come out and told the landlord to fix the issue, and if the issue is still not being fixed, then the landlord has the ability, or sorry, then the tenant has the ability, or should file an application at the landlord and tenant board at that point. Filing cases at the landlord and tenant board can be a very frustrating and long process for tenants. We're seeing landlord applications get scheduled sooner than tenant applications, which is really frustrating, but it might mean that a tenant is waiting like 4 or 5 months to get a hearing scheduled at the LTB. And so if they're looking for a quick fix, like they're looking for heat to be put back on, going right to the LTB is not the best first option. It's best to try and work with the landlord directly, try and get a legal clinic involved. Sometimes it's helpful for me to just write a letter to the landlord, and that puts enough pressure on the landlord to do the thing or to make the fix. But some landlords, as we either know or can imagine, are difficult and don't want to follow their obligations under the law. And so at that point, it might make sense for a tenant to file an application at the landlord and tenant board. But I would say, just for the purposes of the folks in the room and the support you might be providing to tenants who might be coming in and they have concerns about their tenancy, keep 311 in mind. They can be helpful for kind of the immediate fixes of things like vital services being turned off. But if it's kind of beyond that, and if the tenant they've got some protracted issues with their landlord that are not being dealt with properly, I would say refer them to a legal clinic, and we can talk through in more detail what steps the tenant could take to have the issue addressed. So somebody said my clients are complaining about rats in their unit and the superintendent is doing nothing. What are the tenant's rights? I would say call 311. 311 is able to come out and if they see evidence of an infestation, they're able to talk to the landlord about that. If that doesn't get addressed, I would say refer the clients to a legal clinic. And like I said, it might be the case that a caseworker writing a letter to the landlord about the superintendent on behalf of the tenants is enough to kind of like kick them into gear and make them do the thing that they know they're legally required to do. Okay, very good question about do legal clinics help with filling or filing applications at the LTB or only with defending clients? So, like I've mentioned a couple times, our mandate is eviction prevention. And so that means that if, I have two people coming in, one person is facing eviction and one person wants to file a case against their landlord, I'm probably going to be more likely to represent the person who's facing eviction. However, it really depends on the clinic. Like I know different clinics have different policies. At our clinic, we sometimes do represent tenants on their own applications against landlords. Even if we don't represent them, we might, schedule a 2-hour meeting, have them come in, and we will help them with filling out their application and making sure it's filed properly, making sure they have all their evidence together, doing a hearing prep session with them so they know what to expect in their hearing. It really depends on capacity, the merits of the case, and how much support that tenant needs. Like, I think that, our role as a legal clinic is to support those who really need it, and some people are able to represent themselves at the LTB, and the LTB is meant to be a system that people can show up at unrepresented. It's an incredibly flawed tribunal that has a lot of really concerning parts to it. But if somebody, wants to represent themselves and they just need a hand getting the filing in, getting their evidence in, we're also happy to play that role if we're not able to support in more depth with that person. Okay, so one of the questions was about how do we best support tenants to advocate for their rights, and are there any tools that I recommend? Um, it's tough. I would say that if you're talking to tenants about advocating for their rights on an individual level, then make sure you put things in writing. Like that's the main thing that I tell tenants. Stop having these like in-person conversations with the landlord where the landlord can say ridiculous things and you have no record of it. Put it in writing. Make sure you start texting or emailing. If a tenant is just starting out with a tenancy and they don't yet have a lease agreement, I always encourage them to try to get a copy of a written lease agreement. That makes it so much easier. If legal issues come up down the line about what were the terms of the agreement or what, part of the house were you entitled to under the lease agreement, that's going to be contained in a written lease agreement, but it's going to be really hard if you don't have anything in writing because it'll be your word against the landlord's down the line. So get things in writing, get your lease agreement in writing. Another referral, kind of similar to 311. So 311 is municipal. They're able to get inspectors to come out from the city of Toronto to address bylaw issues with properties. A different organ or a different kind of branch of government is provincial. It's called the Rental Housing Enforcement Unit, RHEU. Tenants can file complaints with the RHEU if they feel like their landlord has violated the law. So if maybe like the tenant is having their landlord is consistently entering their unit without giving proper notice, or I've dealt with the RHEU when tenants have been illegally locked out, like a landlord will change the locks on a property without going through the proper eviction process. The RHEU they can be helpful. I don't want to give anybody false hope here that the RHEU is going to come in and fix things. But similar to 311, they come in, they talk to the landlord, they talk to the tenants, they try to remind both parties of their legal obligations under the law. If they feel that the landlord is not complying with the law, they can try and put pressure on them to comply with their obligations under the law. It's not a perfect system, but again, it could be like another pressure point to put on a landlord if the landlord is threatening to do illegal things or is carrying out illegal things. But I think the kind of main thing, especially if we're working with tenants who live in multi-tenant buildings, is for tenants to organize together. Um, Landlords have a lot of power when tenants are kind of picked off individually and they can start putting pressure and threatening tenants here or illegally evicting other tenants here or racially discriminating against another tenant here and trying to make it seem as if the tenants are all separate and not actually part of a bigger body that has power against the landlord. So sometimes you might have clients who are like really fired up about things their landlord is doing or, issues they have in their building and they know other people are having the same issues and they want to get talking to those other tenants. Don't let that slide away. That is like really, really helpful energy to harness that you want to encourage. And so what I always do is I encourage tenants to speak with other tenants in the building that they might know. Like maybe they're all really upset about the above guideline increase notice they got, or maybe they're all noticing that there's pest infestation issues that are going unaddressed for months on end. And they can be very powerful in getting those issues addressed if they join together and work together. And so on the screen are two really great organizations um, that are really good at supporting tenants who want to work together to fight back against individual landlords, or like on the screen I have here, against provincial legislative changes that are being proposed, Bill 60, like I've mentioned a couple of times. So the FMTA, the Federation of Metro Tenants Associations, is really great at assisting tenants. Maybe if you have a small group of tenants in a building who are wanting to get organized, they can assist them with that. And similar with Acorn, Acorn is an organization that does a lot of different things, but they have some really great tenant organizing resources and people who work with the organization. So take note of those two organizations. If you've got a client who you know is really fiery and wants to make some change in their building, I would say encourage that, foster that, and get them connected to some of these organizations. Okay. Okay, so we're now at the end of the formal things that I wanted to talk about. I see there's a question where somebody's saying that they have a client who has declined twice to transfer a unit. The worker keeps saying she does not have sufficient medical information. So what I'm assuming with this person is that maybe they live in subsidized housing, like Toronto Community Housing or some other rent geared to income housing. And okay, great. So people who live in subsidized housing, there's certain circumstances under which they can request to be transferred to another unit. One of the reasons is a medical transfer. For some reason, they might need access to a different space for whatever reason medically. It sounds like this individual has tried to submit medical twice um, to TCHC or to whoever the housing provider is, and they've been declined. Unfortunately, the transfer process with TCHC is really, really difficult. And it really does just come down to how strong is that medical. Often, though, I find that doctors are filling out the medical forms without a really good sense of like what's at stake, or what is needing to be articulated for the tenant to get what they need. And so, I mean, this could be a role for you to play of perhaps drafting a letter to go alongside the medical questionnaire, explaining what the tenant has told you they need in terms of an accommodation or the reasons for the medical transfer, and essentially like probing the doctor to like put that in the medical questionnaire, like please like state these things or provide more detail about this. Because that medical questionnaire is the basis for the transfer and the justifications for denying it or granting it. And so I find doctors are much better able to kind of hit the notes I need them to hit if I've written to them and I've said, this is what I need you to say. Can you please say it? And not in a way that's like, say this verbatim, but just like asking them to provide more of that detail. So, I mean, I think transfers are difficult, but I think that's the one thing I would recommend. So I know we just have a couple minutes left. Does anybody have any other questions? Thank you so much for the questions that have been asked as we've gone along. I hope that the responses have been helpful. And so please feel free to take down my contact information here. Like I said, our clinic, we offer legal services with immigration, housing, social assistance, and employment. I know other legal clinics have some other areas of the law. But I guess first thing when you're trying to assist a client with getting them connected to a legal clinic is look up their postal code, see what catchment area they're in, and then you can go ahead and make that referral. Do all legal clinics do work for housing? Yes, I would say housing is probably the busiest area of law for most, if not all, legal clinics. And so even if you're not in Willowdale's catchment, maybe you're in Don Valley or you're in West Scarborough, they definitely do housing, and there are caseworkers there who can assist clients who have housing concerns. Thank you. Thanks, Sarah, one of our awesome board members, for putting the link about our catchment area. I always get I know some of the streets, but I always get some of them wrong. So it's best to just look at the map. Okay, I think maybe one question here. Will you be able to serve people who are not in our geographic area? So no, we're very strictly guided by who we can and can't serve, and because we're funded by legal aid and we're told to stick within our boundaries and funding to us is allocated based on our boundaries, we got to stick to that. And so if somebody calls us and they say, "I think I'm in your catchment area," one of our staff will look that up, and if you're not in our catchment area, then they'll say, no, you're actually in Don Valley's. Here's their contact information, and you can reach out to them.